I'm just giving everybody a couple of minutes to finish getting in there. We've got a good number of participants now, so I'm going to kick off with the start of the webinar. First of all, welcome everybody, a very warm welcome to this, the first session in our volume 2 of our scheme sessions. Today's session is on protecting the trustee in a corporate takeover situation. And I am delighted to be joined today by both Richard Hawkins, who's a trustee director of the G4S pension scheme, and Maddy Frost, who is a legal director in our team at Gowling. I'm going to hand over to Maddy and Richard to introduce themselves properly and fully in a moment. But before I do, just a couple of housekeeping points. So first of all, we're expecting today's session to last for around 40 minutes. So 40 minutes of talking, that should leave us 15 or 20 minutes for questions. If you do want to raise any questions, please can I ask you to type your question into the Q&A function, which is on the toolbar at the bottom of your screen. And I'll ask Richard and Maddy to pick up as many of those questions as they can at the end. If we happen to run out of time, if we can't answer all of the questions, or if you think of something after the webinar has ended, we will circulate our contact details after the session so that you can contact us separately with anything that you wanted to raise. Just to mention that the session is being recorded. We'll send out the link afterwards to all attendees, and the webinar will be available on demand on our website. If you're not speaking, please can I ask you to go on mute, and cameras will be off for the duration of the session, with the exception of the speakers who will, if technology allows, who will remain on camera. So that's it from me. I'd like to hand over now to Maddy and Richard. Thank you.
Thanks, Liz. Good afternoon, everyone. Thank you for joining us. I'm Maddy Frost, as Liz said, a legal director in the pensions team here at Gowlings. Primarily act for trustees, managing schemes of all sizes, from advising on the more day-to-day legal queries to bigger projects such as the one we're going to be talking about today. So, as Liz said, in today's session, we're going to be talking about how to protect the trustee in the context of a takeover of its sponsoring employer. I'm absolutely delighted to be joined by Richard for today's session, who has some really valuable hands-on experience as a pension scheme trustee. Richard, I'll let you introduce yourself.
Richard, you're just on mute. If you could take yourself off mute, please.
Never trust me with the technology. There you go. I am a trustee director appointed by the group G4S in 2009 and took over as deputy chairman in 2014. I'm an FCA who qualified way back in 1973 and worked in the profession in Belgium and Norway before seeing the light and moving into industry, as we used to call it. And I worked in Africa for quite a while, returning to the UK eventually. And since returning, I pursued a 25-year career in G4S, during which I held a number of senior positions in finance and executive management prior to retiring myself in 2010 as group security and risk director. As well as being a trustee director, I also chair the audit committee and serve on the investment subcommittee. Incidentally, I am a member of the pension scheme myself, which means I have a very keen interest in preserving the benefits of my fellow pensioners. So I'll now hand over to Maddy, who's going to take you through the agenda.
Yeah, just a quick look at what we're going to talk about today. So we're talking about the situation where the corporate is a listed company and a sponsor of a large defined benefit pension scheme, and another entity then seeks to acquire that sponsor. Many of the points we will be talking about today would apply equally actually to non-listed companies, but in this case we have the extra excitement of the takeover code, which I will mention a bit later on. So as I said, we're considering the takeover of a sponsoring employer from the trustees' perspective. We're not considering a sponsor in distress. That will be the topic of the next scheme sessions webinar next week. we will be looking at the context of a sponsor that's pretty healthy, meeting its financial obligations, including to the pension scheme, with no suggestion that will change. Now, of course, with Richard's presence, you will know that this session is loosely based around a real case. However, we are bringing together combined experience on various transactions, so no confidential information will be given, and our discussion today should not be assumed to relate only to one particular case, particularly actually the information we give about trustee powers and the regulator's involvement. To ensure that we protect confidentiality of all parties, we've deliberately masked some information, but without changing the substance of the points that we want to make. So that said, in terms of the agenda, I will talk about the initial legal considerations when the trustee first hears that a company is expressing an interest in its sponsor. Richard will then talk about some practical considerations and the trustee's role throughout the process. And I would then talk a little bit about the trustees' interaction with both the pensions regulator and the takeover panel, and then we'll both share with you some final thoughts. So just to give you a bit more background on the next slide, please, Rosie, to what we're talking about today. We're considering the takeover of a company, which was the sponsor, as I said, of a large DB pension scheme. Rather unimaginatively, I expect, I will refer to the company as the target, or I might slip into referring it to it as the sponsor. So a bidder, let's call that bidder one, stated its intention to acquire control of the target. It was a hostile bid, so it was not supported by the target company, who considered they undervalued it. Shortly afterwards, the target received an expression of interest from another bidder, we'll call that bidder two, regarding a possible offer of the shares of the target company. Now, if either bid was successful, there would be a resultant change in the covenant that was supporting the scheme, and there would be increased debt. So ultimately, the bidder from bidder two became a recommended and successful bid. Before that, though, there was a period of uncertainty where both bidders were making offers for the target company in what was, I think it's fair to say, at least in part, a pretty acrimonious process, with accusations being made, particularly by bidder one, in the press regarding the target's running of its own company and its funding of the pension scheme. And it didn't stop there. It also accused bidder two of not being a serious buyer. And I can say all that because it was all widely reported in the press. But this meant for the trustee, that there was this period during which the trustee was having to have discussions with two bidders. Nobody knew which, if either, actually, of the bidders would be successful. So the trustee therefore had to get itself to a place where it had negotiated a package with both bidders. Now, of course, this in itself had challenges. For example, to what extent should the trustee compare or prefer one bidder or package to another? And we'll talk about that a bit more as the session goes on. But also, of course, the trustee had to be very mindful of its ongoing relationship with the target company as its current sponsor. The trustee was involved in the process from the start, not least because it had some special powers, which I will come on to in a moment. And unsurprisingly, TPR was very interested in the transaction. I'll also look at how the strict timetables on the City Code of takeovers and mergers impacted the trustee's consideration of the transaction. I'm just going to pass over to Richard now, who's going to give some comments on how this all felt from a trustee perspective.
Yes, yes, it did feel quite peculiar, really, because all this happened during lockdown. Most of it happened during lockdown, so everything was on Zoom calls, etc. But in terms of timing, the initial corporate interest of the first bidder and then the second bidder, particularly on the first bidder, it did come as a particular surprise to the trustee. However, happily, we had some solid governance procedures in place, which meant it could adapt quickly to the demands that were placed on it. I will talk in a moment about some of these processes were and how it is possible for a trustee to be prepared and to expect the unexpected, because rest assured, there was an awful lot of unexpected arising. However, having good procedures in place and a good communication between your trustees, directors, advisors, and the sponsor gave us the confidence and tools at the outset to enable us to negotiate with the bidders and keep TPR and the takeover panel informed and basically happy. So now I'm going to hand over to Maddy.
Thanks, Richard. Yeah, so let's flick to the next slide, please, Rosie, and we'll have a look at some of, and the following one, please, initial considerations. So I'm obviously going to talk about the initial legal considerations, and actually, to be honest, they were probably the key considerations throughout the whole process. So let's talk about that trustee power. A really key part of this scenario was that the trustee had an important power in the scheme rules. As I said, I'm not going to describe to you what the exact power the G4S trustees had, but let's say for the purpose of today's session that on the takeover of a sponsor, the trustee had a power that meant if the trustee decided that a takeover event had occurred, it meant that that gave the trustee a unilateral contribution power. So clearly control of the contribution rate is quite important power, and one that the bidders were very keen to ensure that the trustee did not use. The trustee decided that a takeover event had occurred in relation to bidder 1 and that that takeover event continued in respect of the bid from bidder 2. Both bidders approached the trustees with proposals as to how they would fund and support the scheme. So this meant the trustee had to work to understand the impact on the covenant if either of the bidder was successful, and to assess each of their proposals in that context. And unsurprisingly, a condition of the packages offered by both bidders was that the trustee must agree to waive its power on a takeover that it was given under the rules. Now, this was clearly a very important and tricky decision for the trustee to make, but it did certainly give the trustee leverage in the negotiation of the packages with the bidders. Now, it needs to be clear, it was not the trustee's role, or of course within its power, to control the outcome of the bid. That was a matter for the shareholders. The trustee just needed to ensure that the scheme was in a good place, regardless of the outcome. And actually, in each case, with each bidder, the decision the trustee made was that if the transaction proceeded with either of them, was that the trustee would be in a better position with the package offered, which includes the waiver of its takeover event powers, than it would be to not agree to a package, retain its takeover event powers, and then attempt to renegotiate in the event that a transaction eventually proceeded on the basis it did. So with each bidder, the trustee entered into a terms of agreement that documented the package that it considered would be favourable to the scheme. And with the successful bidder, of course, this was then turned into a formal legally binding pensions agreement, which sets out the agreed terms. So things you would see in those kinds of agreements will generally be funding provisions, any upside sharing, downside protection, covenant monitoring, and any protections agreed in respect of covenant leakage. That's not to say that the trustee would have accepted any package. If it could not have reached an appropriate mitigation package with either bidder, it was prepared to proceed with the process, keeping hold of its takeover event powers and seeing what would happen as the next step. And of course, not all pension schemes are going to have a power that's triggered on or leading up to a takeover, but the trustees will be expected to bring any tools available to them to the table, whether that's in bringing forward a valuation or looking at other powers in the rules, such as investment of the assets, which leads us on to TPR expectations. TPR expects trustees to exert an influence. They must have a seat at the table. In this case, as I said, both bidders engaged with the trustees at an early stage and presented proposals to them. However, this doesn't happen. Trustees should actively seek engagement to understand the implications on the covenant supporting the scheme, and also the bidders' plans to fund the scheme. TPR expects this, and of course trustees would want to champion the interests of the scheme beneficiaries. And the third initial consideration, and a key consideration throughout, was conflicts of interest. The trustee had an established conflicts of interest policy that was put to the use at the absolute get-go. This meant that one of the trustee directors did not take part in any discussions relating to the transaction at all, and later on in the process a further trustee director was excused from certain meetings. It's of course largely due to the director's role as an employee of the target company and the information that they would be seeing in that role, particularly in the context of the hostile bid, where the target was mounting a defence document against that bid. So any information that the trustee director would see in that context, of course, could not be brought to the trustee board. But the quick implementation of the conflicts policy meant that there was no scope for the trustee decision making to be challenged on the grounds of conflict of interest. This was absolutely key factor for the pensions regulator, and was actually really helpful that the trustee could demonstrate that this had been considered at a very early stage. So Rich, I'm going to pass over to you now to talk about some initial practical considerations.
Yeah, next slide, please. Yes, so it was difficult to be fully prepared, having been through this for a transaction, but there were some things that we already had, which were quite useful. We had a documented crisis management procedure, which included a tried and tested communication system, which involved, so the trustee directors could be communicating even during lockdown together, as they say. We had a chairman, and still do, who was I hope he's not listening, who was a highly experienced professional trustee. So that helped. And we had a team of advisors who knew the scheme because they'd worked with us for a number of years. All the advisors had worked with us for a number of years. And of course, we had a very good relationship with the sponsor, who at that time was G4S. So there were processes in place to mobilize the trustee directors, because obviously the PLC could not tell us anything until there was a proper expression of interest. So they told us, and we had to get things sorted out pretty quickly. And with the WhatsApp group we had, that was pretty good, pretty easy. That was a problem that was pretty easy to solve. We had regular regular trustee meetings, tended to be 8 o'clock in the morning, and often the same day when things had moved on, even in the evening, we used to have meetings. So there is a big commitment by all the trustee directors to when these transactions arise. Bearing in mind, of course, we had 2 bidders, so we had to repeat the process. We were absolutely convinced that we should keep minutes, because we knew we had to speak to TPR. So we had our scheme secretary took minutes of all the meetings, which were circulated during the day and all that type of thing. And this audit trail was really important. Our legal, actuarial and covenant advisors, as I said, knew the scheme well and worked together. So it was almost, when it started, everybody knew everybody else, and we all had a good idea which way we were heading. On the top of that, the trustee appointed an independent communications PR company to deal with the press, advise us how to deal with the press, bearing in mind what Maddy said before, that one was a kind of a hostile bid and was running to the press all the time. And on top of that, we also had that they also advised us on communicating with our members, which we'll talk about a bit later too, how we communicated with them. And clearly the communications people, they were involved in our daily meetings too. As we said, the legal advice we had, which Maddy has been through, about clarifying the powers, etc., and the conflicts of interest, which we were quite keen to ensure that what we had was fit for purpose. And and legal advice was taken at the outset in a number of important areas. Covenant advice was also taken. Again, our covenant advisors attended all the meetings, considering the impact of any transactions on the covenant. So the 2 lots of transactions were going to be on the table, and we had to decide on that. Of course, our scheme actuary was able to comment on the funding implications and the adequacy of the funding package offered by the bidders, and all of which were vital to the final negotiations that we had. So having gathered the advisors, we then started to look at our communications, which I think was the very I think it's the most important thing of all on these transactions. So we talked about the communications with the directors, of how the trustee directors, of how we could keep in contact and how we can make decisions, and the other people we had to turn were the most important people of all, who are members. And we sent letters to them. We didn't. We have 24,000 people, members, at various stages. So we had to send them letters, supplemented by FAQs, etc. And towards the end of the process, we actually put a separate website up, independent website up, for questions if they had any. To be frank, the letters were, I mean, the letters were sent out just to explain to everybody that we still have the reins in this transaction, that we are still that we still had their interests. They were still going to have their pensions paid now and in the future. So it was really to beef up the view, which we did. I think worked out quite well in the end. Press interest. Well, as you heard, there was quite a lot of press interest, and we managed to deal with it over the period of time. And our PR advisors were quite experienced in this area of pensions. Obviously aware of the takeover code and what you could say, what you couldn't say. I mean, generally, in terms, most of it was no comment. So, but we needed that backup from the PR company. So I'm going to move on to the next slide, I think. Yes, please. So trustees' role throughout. Well, it can be summarised. Members' interests are at the forefront, are paramount. That's what we're there for. We're not there for judging a bid. Obviously, we want to get the best deal possible, which will involve some judgments. And we wanted to ensure that our people had security of benefits. And we had to explain to our members that we're not in control of the outcome, because obviously they didn't know that really. And with that, we actually sent letters out after each bid was received. Right, so they knew. We could, obviously we're controlled by takeover code, there wasn't much we could say, but again it was emphasizing, look, your benefits are secure. We will make sure we secure your benefits, and we were aiming to keep their benefits at a level in excess of what they've got at the moment. In other words, with covenants and things like that supporting them. I think that's really all I have to say on that at the moment. Can we move to slide 8, please?
Okay, this is
Which Maddy.
Yeah, thanks, Richard. This is me again. So preparing for the regulator's scrutiny. Now, I mentioned that TPR was involved very early on in the context of bidder 1, remained involved throughout the negotiation with bidder 2. TPR actually put quite a lot of pressure on the trustee to negotiate a favourable package for the scheme, no less than you'd expect, I suppose. Although our experience was that potentially more pressure was put on the trustee than the bidders themselves, and the trustee chairman had to keep TPR appraised of developments and respond to their queries promptly. It was really important to TPR that the trustee was aware of and prepared to use the powers available to it. The TPR is clear that trustees should be proactive and should be robust. It was also important that the trustee really understood the terms proposed by each bidder and the impact that that would have on the scheme. TPR expected the trustee to have the support of its advisors, but also that the trustees had an understanding of the existing covenant supporting the scheme and what covenant would be available if either bidder was successful. I mean, the use of TPR powers was not a direct issue. But in transactions like the one we're talking about today, the awareness of TPR powers is always a backdrop to the negotiation with the bidders. And the bidders are usually very aware of the potential for a TPR investigation, and that if TPR considers that arrangements have not been put in place to adequately mitigate any potential material detriment caused by the transaction, it will consider the merits of investigating. So the desire to satisfy TPR that appropriate arrangements were being put in place was a key issue in the transaction, and something that the bidders took very seriously. And as I mentioned earlier on, actually, as well, that the management of conflicts of interest was an absolute key factor for TPR. Rich, I don't know if you just want to say a few words about TPR, yeah. your view of TPR.
Well, not for publication, maybe. No, they were very. We've dealt with TPR over a number of issues over the past, since I've been, well, since they were involved, really, and. We were aware that they had to be involved in this if the transaction was going to take place, even if transactions didn't take place. Yes, they were. We communicated with them quite regularly, and often, maybe it could be 2 or 3 times a week sometimes, because they were really anxious that they should they were anxious to have a say, but they didn't want to be involved in the negotiations effectively. And they wanted us to do the negotiations, which it was in the end. All discussions with TPR were minuted and letters were exchanged so that we had what was their position and what was our position. And we had specific meetings, again, because it was locked down through Zoom, with TPR, and kept them up to date throughout. The fact is that both TPR and trustee interests were aligned in securing the benefits for our members. We just approached it from a different way. I have to say, TPR was very demanding on the trustee. At times, this felt difficult, as they appeared to drive the assessment process without being hands-on in the negotiations. However, all in all, I think in the end, they were a helpful ally. Certainly useful ally in our corner. There's a question mark on there, but I think they were. But it did complicate things quite a lot. But we have to deal with TPR anyhow. So we'll pass on to the next slide, please. That's Maddy.
Yeah, thanks, Richard. So I've mentioned it a couple of times, the takeover code, and it was particularly interesting in the context of a hostile bid, but it actually also proved quite important in the way that the trustee communicated with both bidders and also with its membership. So I'm sure you're aware the City Code on Takeovers and Mergers is a statutory framework for takeovers, aiming to ensure that shareholders are treated fairly. It includes provisions to encourage that early dialogue between the trustees, the targets, and the bidder. It also mandates some strict timetables. So this is intended to balance that need for the target shareholders to have time to consider the bid, whilst also preventing the target company from having this bid hanging over its head indefinitely. So for the trustee, the code was firstly relevant in what the bidders told the trustee and what the trustee then told the bidders. So the bidders actually approached the trustee, each of them when their offers were publicly announced. So at a time which it was easier for the bidders to discuss matters with the trustee. Now, the code does actually require the bidders to include statements of their intentions in relation to the pension scheme in their offer document. And it doesn't have to be a very detailed statement. Actually, it wasn't in this case. It was just a statement that the bidder intended to address the underfunding and to ensure that the interests of scheme members were safeguarded. Although the takeover panel does take such statements seriously and expects them to be adhered to. More information about how the bidders proposed to achieve this objective was communicated to the trustee in the forms of the mitigation packages that were put before the trustee, although this was, of course, not publicly available information. Now, secondly, the takeover code meant that the information flow from the trustee to the bidders had to be equal. So what the information that the trustee was asked and provided to bidder 1 equally provided to bidder 2. This was actually reflective of the approach that the trustee took in the negotiation with the bidders, to have an agreed package with both, not to take sides, but to just really focus in on whatever the outcome, what is the best position we can be in for our membership. Actually linked to this also was the trustee's decision whether or not to put an opinion in the sponsor's defence document in respect of the hostile bid. The trustee didn't. It's quite unusual, I think, but not unheard of for trustees to include an opinion. But this just wasn't in the trustee's focus at that point to comment one way or the other. And although it wasn't a sole factor in the trustee's decision not to put a comment in, it was mindful throughout the process of maintaining that good relationship with the target company. Of course, that's the covenant on which it relied, and for all it knew, both bids could fail and it would be back in the position it was with its current sponsor. And finally, the code was also relevant to member communications, and the chair of trustees actually approached and met with the takeover panel, presenting to the panel the proposed communication to members, just to ensure that it did stay on the right line of what the takeover panel would be happy with to be communicated. On the basis you communicate with your members, that information then becomes public. Okay, so we're on to some key takeaways. Thank you, Rosie. So just to bring some of these themes that we've been talking about today together, be prepared. Rich has talked about how it can be difficult to be fully prepared for a situation like this for trustees and advisors. But there are certain things I think that you can do to be in the best position you possibly can if faced with a takeover situation. First thing, be aware of your powers. Knowing what leverage you would have is really important. So although the trustee at the start of this process took legal advice clarifying the parameters of its powers in the rules, it of course already knew that it had the takeover event powers, and we'd recommend that all trustees remind themselves of the scope of their powers if they were ever faced with this corporate activity. And it may, to be honest, just be a matter of understanding the limitations on the trustee powers, knowing what you've got in your armour and what you haven't. In my experience, that doesn't necessarily mean the reduction of an expectation to negotiate the best package you can, whether you have some strong powers or maybe not such strong powers. But part of this being prepared is having good governance. This will be expected, of course, of all trustees, and it will be ramped up when we get the single code. Richard said, the transaction took up a significant amount of trustee time and at times was very fast paced. So having good governance procedures in place to be able to call a meeting, to have the meeting minuted, to ensure requests were put in writing, that was really important. Also to have that fit for purpose conflicts of interest policy that you can demonstrate was implemented right at the outset was so key to the transaction. And a final takeaway from me, post-event, it's not over when the documents are signed. The trustee should be live to any ongoing monitoring that may be needed to ensure that the new owner complies with the provisions of the pensions agreement that you spent the past few months fighting hard over. So I think if a takeover is then successful, the new owner will go for a period of transition. And it might be actually that at that point, adhering to the pensions agreement might just not be in the forefront of minds. So the trustee should make sure it's in a position to know what it is expecting from its new sponsor and to ensure that it gets those things that it's expecting. Richard, I don't know if you have any final thoughts you'd like to share.
Yes, next slide, please. Yes, be prepared to negotiate as trustee directors. Get the best deal possible, which will enable you to get the best deal possible for your members. And negotiations effectively, I would say, took about 3 to 4 months from flash to bang. So it was, as we said, quite a huge use of time. But if you don't negotiate, you don't get the best deal. It's never too early preparatory work, right, which would include stuff like assessing, finding out what the trustees' powers are actually if a takeover is ever likely, and what strategy, and what strategy you would wish to follow. And I think that's quite important. Make sure all trustee requests are documented in writing to determine what it wants. And that's what we did all that. We needed, as I said before, you need an audit trail, but you also need to be able to go before TPR and say, well, we told you that, and it's in that letter. So be ever mindful of relationship with the sponsor, all right, during this process, because we had 2 bids on the table and maybe none of them have got it. Maybe none of them would have been able to get it. So we'd still have to deal with the sponsor. And also the relationship with the members. At the end of every meeting, we're only here, we used to say, we are only here for the members. And that's all the things, that's our total goal. And Maddy alluded to it a little bit, but we had to monitor the implementation of the pension agreement after the transaction was completed, and over a period of time, over some things that were agreed in the pension agreement. And really, thank God we did, because we had to we had to point out 1 or 2 things that weren't exactly going the right way, which have all been altered, all misunderstandings, obviously. But it's a vital thing that we should be doing. On the pension agreement is basically encapsulates what we want. This is what we've agreed. So we want the new company to follow that agreement. I think that's really my takeaways anyhow on that. So.
Thank you very much, Richard and Maddy. We do have a little bit of time for questions. You've got about 15-20 minutes, something like that. So just as a reminder, if you've got anything that you wanted to raise or any comments that you wanted to mention, please just type that into the Q&A function on the toolbar on your screen. While we're sort of waiting for people to do that, I suppose I had a question, and it's probably for you, Richard. and that's just around the members and how they reacted to it. So you're obviously very keen on keeping members in the loop as far as possible, and the communications that went out to the members, but you obviously had to be very careful as well what you were able to say to members. And I can think of, you know, schemes that I'm involved in where if something like this happened, there'd be a million questions from members. Members would be getting in touch with the trustees on the board that they knew. You know, there would be probably quite a lot of concern. So I'm just interested to know whether that happened in your situation, and if so, how did you kind of manage those requests?
Yeah, so yes, we did have that. I personally got quite a few telephone calls about what's happening, etc. But you're ever cognizant of the fact that you're governed by the takeover code, what you could give to the members as well as anything else. So we reported any contact we had with our members, so that and that was reported within the meeting structure. And I know that the employee elected members got even more questions than the members. Strangely, we didn't get, because we issued FAQs with a lot of, on the two major letters we sent out. There weren't a huge amount of reaction to the FAQs, but certainly on the personal side. So any trustee director who got a question would report that question, and if you couldn't answer it, you say you can't answer it. It's the easiest thing to do because we are governed by takeover code.
Yeah, you almost have to have a script, don't you, to make sure that everybody's saying.
Well, we did have a script, but that script was the first thing that you throw out, actually, because no one ever got the right question.
Yeah.
That's the problem.
Okay,
yeah.
thanks, Richard. Thanks, Richard. That's interesting to hear, just from a practical perspective. Another thing that sort of struck me was that you know, although you had your conflicts of interest policy, there were clearly two trustee directors who either took no part in the discussions or were only able to take part in some of the discussions that you were having. And I wondered whether TPR reacted to that at all. Did TPR ever make a suggestion that there needed to be an independent on the board, or I don't know if it was another independent? You mentioned you had a professional trustee on the board already, Richard.
Yes.
Did you get any of that pushback from TPR?
We had pushback on conflict of interest, in fact, because they didn't believe what we sent to them in the first place, which was and we sent an accurate. And we had a number of conversations with them saying we believe that is, you know, that we've dealt satisfactorily with a conflict of interest. I don't think they ever suggested we have another independent person on the board. It was the chairman who is the professional independent director. So yeah, really, we had employee nominated members, and we have company members, company nominated. I, for instance, was a company nominated back in 2009. So I think everybody had, we were quite satisfied. In fact, of course, we did refer to Gowling's to make sure that, and we had an opinion which said, yes, that's okay. And they were the things where they also suggested that, you know, the two should be recused, you know, when there are certain discussions going on. In fact, we've explained that.
We actually took some time to talk to a number of the trustee directors individually about their positions. It can be a very tricky area for trustees to navigate. So I think in some of the cases there was probably an abundance of caution in our approach. We definitely didn't want any suggestion that there was any conflict of information, and quite frankly, you don't want to put people in that position with what they might be seeing in their day job is relevant to their trustee role. So it's something that we took very seriously from the outset. The trustee took very seriously from the outset, and absolutely was helpful throughout the whole process, to be honest. And I think it was just lucky actually that there's a good, solid, strong trustee board with a number of directors that all wanted to be involved in the discussions going forward, despite the regular 8 a.m. starts. So there were still plenty of opinions to be voiced on the trustee board, despite managing those conflicts effectively.
Did you have any trustee directors who struggled with the volume of work that was involved? I mean, again, thinking about some trustee boards that I'm involved in, people have very, very busy day jobs. And so I was wondering whether there was a need to set up subcommittees, for example, to make decisions quickly in some situations.
Shall I answer that, Maddy? Yeah. Well, we did kind of have a subcommittee that dealt with the PR. All right. And of course, I'm retired and the chairman's got other things he's got to do. But generally, the people who had full-time jobs, they were, and it's probably a bit, it was probably fortuitous that it was during lockdown too, actually, because a lot of the work was done during lockdown, where people could work from home and had a few more hours to do things, as they say. So yeah, we didn't really have a problem with that. And if anybody couldn't make it, they're excused, but they got the minutes.
Yeah.
Right. So and the minutes were fairly detailed.
Yeah. Okay. Thanks very much. I suppose I've got one final question before I wrap up. And I mean, Maddy, maybe this is one for you, but it sounds to me as though there was some very strong trustee powers in this particular scheme. And it sounds like it's quite an unusual power. So I was thinking about the schemes that I advise. I can't think of any that have, you know, a similar power. Do you think the deal that you were able to strike was only possible because you had that strong power to start with?
I think that strong power got the bidders engaged with the trustee nice and early. There was a suggestion by the bidders' lawyers that potentially that the power wasn't the power that the trustee believed it was, and that it wasn't appropriate to use in the circumstances, but nobody wanted to spend any time and effort fighting over that, when I think there was an acceptance that regardless of that power or not, there was TPR involved, the trustee had its duties to secure members' benefits. It was widely publicised in the press. So although I think it was a helpful tool for the trustee to have, I would suggest that it would have got to a very similar package regardless.
Okay. Interesting. Good to know. and yeah, interesting thoughts.
I wouldn't want to put trustees off fighting for their corner if they don't have one of these powers hidden in their rules somewhere.
All right, well, that's brilliant, and thanks ever so much, Richard and Maddy, for an excellent session and actually a real practical insight into how these sorts of situations can pan out. So thanks very much. I mean, I think for me, there's probably 3 key takeaways. One is like a good Boy Scout, always be prepared, and it kind of sounds as though you can have things in place right from the start, even if you've got nothing on the horizon at the moment. Actually, that you had policies and things in place that were really useful to have there when this situation started. Number 2 is that the trustees obviously are playing a key role in the negotiation with the prospective new employers to protect the scheme and the members. And number 3 is obviously, as with everything, maintaining that positive relationship with the employer and with the prospective new employers was absolutely key to making sure that you got the best outcome for members. So as I say, that yeah, thank you ever so much. Thanks ever so much for taking the time. In particular, thanks to Richard for joining us. As a reminder, 2 things. So first of all, if you've got any further questions that you think of after the session, please get in touch with one of us. Our contact details will be circulated afterwards. And second, just a plug for our next scheme session, which is happening next week. And Jason Coates will be chairing a session on dealing with a distressed employer, again, taken from a real life situation that we advised on very, very recently. Thanks very much, everybody, for joining us, and we'll hopefully see you soon.